Hello and welcome to today's meeting of Democrats of Greater Tucson. My name is Larry Bodine. I'm the president of Democrats of Greater Tucson, and it's just a thrill to see everybody at today's meeting. A couple of quick announcements to make. As I'm sure you all know, December 7th, next Monday, is our annual Democrats of Greater Tucson election. We have 5 officer and 6 member at-large positions. You are absolutely free to nominate yourself, and several people already have. So you'll shortly be receiving an email that lists all of the people who have identified a position that they'd like to run for. And if you wanted to be included in that, please send your nomination to Christina Early or to me. Everybody should have gotten, if you're a member, you should have gotten a postcard and an email with a link to register for that meeting. It's for members only, so please don't share the link. And if you are a member and you did not get the postcard or email, please contact me and we'll get that squared away. And with that, I want to turn it over to Stephen Linder, our treasurer, who has an announcement to make.
Yes, Lucy Messing, one of our members, asked me to make this announcement. As you know, there's an upcoming an election and also a reorganization meeting for Pima County Democratic Party, in which Lucy is running for chair. And she just wanted to let you know that she's going to have a Zoom meeting Saturday, December 5th at 11 a.m. Now, in order to get the link, I'm going to put into the chat her email and the website in which you can then get the link for her Zoom meetings, and you can do that on your own. I'll put that into the chat and you can get those addresses there. Also, I'm very happy that a lot of you have decided to pay your dues and renew, and a lot of you are doing that through Act Blue, and that's fine. But you can also do it, if you don't want to do it through Act Blue, you can just send a check to Democrats of Greater Tucson, Post Office Box 41573, Tucson 85717. You can do it that way, or through Act Blue, as most of you have been doing. And I thank you for what you're doing for this organization, and let's keep up the good work.
Absolutely. Thanks, Steve. I wanted to stress that if you would like to come to the December 7th meeting and you're not a member, simply go to this address. It's thedgt.org. Hope you can all read that. And you can pay your dues online and become a member. We would love to have you. And so with that, let me introduce our speaker. So our speaker today is Bob McWhirter. If you remember back to in August, he gave a wonderful and informative presentation to Democrats of Greater Tucson, and he's here making a return visit to the bluest county in Arizona. So Trump claims to, make America great, and he keeps finding himself bumping up against the greatest charter of government on earth, and that is the U.S. Constitution. So Bob practices law in Phoenix, and he's an award-winning, internationally recognized speaker and author on trial advocacy and immigration law, as well as the history of the Bill of Rights. In fact, he wrote a book called The Illuminated History of the Bill of Rights. He's a certified specialist in criminal law with the State Bar of Arizona and is a first chair qualified lawyer to defend capital cases in the Arizona Supreme Court. And with that, Bob, take it away. We want to hear all about litigation involving Donald Trump.
I am very happy to say, as you all may know, I have given this talk many, many times over the last 4 years. I am happy to say that, and it's my great and fervent hope that this will be the last, if one of the last times I will ever have to give this talk again. If I was to put all the talks together, I think I have about 12 or 13 versions. I could literally have you here for about 10 hours straight just on the peccadillos of Donald Trump and the Constitution. So I'm happy to say that I'm not going to have to keep giving this talk again because he doesn't have the control over the Constitution that he used to have. So again, so here we are. This is for today's date, introduction. This, of course, is my book on the history of the Bill of Rights. So we are in the waning days of Trump at last. Couldn't happen soon enough. I always begin my talks with, let's make the Constitution great again. Louis Brandeis wrote, the greatest menace to freedom is an inert people. That's in Whitney versus California. And the point is to learn about the Constitution. We have to endure through Donald Trump in this case to learn about the Constitution, but there we are. Thucydides wrote, here in Athens, each individual is interested not only in his own affairs, but in the affairs of the state as well. Of all people, we alone do not say that a man who takes no interest in politics is a man who minds his own business, but we say that he is useless. Well, the framers of our Constitution read Thucydides, and they didn't want us to be useless. The Greek word idiot, our word idiot, comes from the Greek idiots, which is a person incapable of engaging in the public sphere. So it might not just be somebody who has limited mental capacity. It might be somebody who's just character flawed, can't engage in the public sphere. It's idiots versus pelots, the public citizen, which is where we get our word police, metropolis, all those words. We need to be the engaged public citizen. So let's jump into Donald J. Trump and the pardon power. For the topics today, I tried to select things that are still going to be relevant in the next month or so. And of course, the pardon power is relevant. As there's a long tradition of extending it, we just had Thanksgiving, a pardon to the Thanksgiving turkey. Trump and his former friends, he's already pardoned Michael Flynn. He could pardon Manafort. He could pardon Carter Page. Roger Stone, he commuted his sentence, which is effectively a pardon. Manafort cops a plea, of course. Trump, can he pardon him? Well, the ship has already sailed. Mueller already knows what Manafort said and can compel him to testify. One of the things about the presidential pardon, it's only for federal crimes and federal subjects. So everything that Manafort had could go to the New York State Attorney General, and Trump and all of his cronies and his family can still be prosecuted in New York. Part of the problem, if he contradicts himself, et cetera, all these things. Mueller ain't going away. Let me skip through this rather quickly. Just a side note happened with, again, Giuliani as he started into his digression into kind of just irrationality. Look, I'm not going to be rushing to having Trump testify so that he gets trapped into perjury. When you tell me that he should testify because he's going to tell the truth, he shouldn't worry. Well, that's so silly because it's somebody's version of the truth, not the truth. The truth is truth. No, it isn't. Truth isn't truth. That's just a remarkable statement for the ages when you start saying truth isn't truth. Next day, he puts in, my statement was not meant as a pontification on moral theology, but one referring to the situation where two people make precisely contradictory statements. The classic he said, she said puzzle. Sometimes further inquiry can reveal the truth, other times it doesn't. So then he makes an astounding statement that truth isn't truth, followed by an utter and total non sequitur about a pontification on moral theology and all this kind of stuff. Whatever. So here's the whole question, can Donald Trump pardon himself? We'll all agree the US president has complete power to pardon. Why think of that when the only crime so far is leaks against us, fake news? Well, that's actually not totally true, that the president has complete pardon power. Article 2, Section 2, Clause 1 of the Constitution says, the president shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Federalist number 74 from Alexander Hamilton, he writes, in seasons of insurrection or rebellion, there are often critical moments when a well-timed offer of pardon to the insurgents or rebels may restore the tranquility of the Commonwealth. Okay. Ford pardoning Richard Nixon is an example. At the time, I remember me and my family thought that was a terrible thing that Gerald Ford did. You know, in retrospect, I think a lot of people say, hey, it allowed the country to move on, et cetera. You know, that was probably the right thing to do at the time. Now, the purpose of the pardon power is to create peace after civil unrest. For instance, after the Civil War, there was a broad general amnesty. Or it also is a holdover from the kings to give mercy after criminal justice system has imposed a sentence. For instance, the crack versus powder cocaine discrepancy in sentencing, the Obama administration issued kind of pardons and commutations to rectify what was clearly an injustice that happened through the legislative process and through the prosecutorial process. So here he has this position that he thinks he can pardon himself. Okay. As has been stated by numerous legal scholars, which ain't the case, I have absolute right to pardon myself. But why would I do that when I have done nothing wrong? In the meantime, the never-ending witch hunt, which led by 12 very angry and conflicted Democrats and others, continues into the midterms. So first of all, now, by the way, if I was Donald Trump's lawyer, I would tell him, do not pardon yourself. It's a really bad move. See, a pardon is an admission of guilt. It's the premise. You have to admit guilt to get a pardon. Otherwise, there's nothing to pardon you for. Trump's self-pardoning, okay, only later could it be a defense to a criminal charge, okay, because it's a defense after the fact, right? Self-pardon would be an impeachable offense. So we don't have to worry about that because he's finally leaving office. But the point is, if you pardon yourself, you make an admission of guilt, because that's what you need to do by definition. If that pardon is later found to be unconstitutional, because, you know, pardoning is not a reflexive verb, it's something you do for somebody else, then you've just made an admission to a crime and got no benefit for it. So if I was Trump, I would tell him, if I was his lawyer, don't pardon himself. I've also kind of thought that if Donald Trump was to ever hire me, I would charge him millions and millions of dollars and have a clause in there that as soon as I had to ethically leave his representation or he doesn't follow my advice, I would leave and I would keep the millions and millions of dollars and I would make sure that I got paid up front, unlike the contractors that used to work for him. Oh, okay. So let's talk a little bit about Donald Trump and the Supreme Court. There's a lot of Catholics on the Supreme Court. The Supreme Court is almost totally made up of Catholic and Jewish persons right now, which is the first time in history that's ever happened. There's no Protestants left on the Supreme Court. There's actually 6 Catholics. In the first 100 years, justices were almost always white male Protestants. Of the 112 justices who have been appointed to the court, 91 have been from various Protestant denominations. Only 12 have been Catholics. And any number are sitting on there now. The first Catholic was Roger Taney, who was the first Catholic justice, the first Catholic Chief Justice, and of course, he wrote the Dred Scott decision. So you've got these little changes in the court. It was going to be, of course, Merrick Garland, who was Jewish, and then Gorsuch came in. Gorsuch was raised a Catholic. He's Episcopalian because he met his wife in England. So I guess you could say he's now a Protestant, and that's a Protestant member. So there you go, kind of Catholic light. One thing about Neil Gorsuch is the first time a justice ever served with the justice for whom he clerked. There have been any number of ex-Supreme Court justices who go on to become Supreme Court justices. But Gorsuch clerked for Kennedy and then ended up serving with him for a brief period of time, until, of course, we got Brett Kavanaugh. Of course, we all know about the passing of Ruth Bader Ginsburg, and we now have Amy Coney Barrett. Trivia milestones, Sessions versus DeMia was the first time that Ginsburg assigned a majority opinion in her 25 years on the court. Although Ginsburg was the oldest justice, she wasn't the most senior justice. Seniority is determined by time on the court and whether you're Chief Justice or not. Okay. course, she is the only justice to recently have movies made about her, like RGB or RBG. Since The Magnificent Yankee came out about Oliver Wendell Holmes Jr. in 1954. And you can get a Ruth Bader Ginsburg tattoo. I don't think any other justice in history has had a tattoo. This woman has been iconic on the court, and remarkably so. Again, I would defy anybody to say that there's any other justice who's ever had their own tattoo. Oh my, Ruth Bader Ginsburg. We will not see her like again soon, that is for sure. So Donald Trump, why did he pick Kavanaugh? Kavanaugh supported presidents under investigation. We should not burden the sitting president with civil suits, criminal investigations, or criminal prosecution. And if the president does something dastardly, the impeachment process is available. That's what Kavanaugh had written in an article, which made him very attractive to Donald Trump. So of all the people Trump could have picked, he ends up landing on Kavanaugh and pushes him through, even when Kavanaugh's nomination had some serious, serious problems. He could have easily dropped him for somebody else, even Amy Coney Barrett, but anyway, he stuck with him, and I think this is a large reason why. Okay. By the way, it was Kavanaugh who had worked for Kenneth Starr, investigating a president who was a sitting president, doing exactly contrary to what he later writes should not be done with a sitting president. All right. Maybe his thinking evolved as time went on. To be a member of the Supreme Court or the federal bench, you have to be a member of the Federalist Society. It's kind of like back in the old Soviet Union, if you wanted to get a promotion at your work, you kind of had to become a member of the Communist Party. Well, that's almost what it's like for the Federalist Society to become a federal or state court judge. Basically, Trump gave over his nominees to the Federalist Society, all of his nominees, and Mitch McConnell rammed all of this through. It's often said about Trump's legacy being the federal judiciary. I don't think that's Trump's legacy in the least. I think that's Mitch McConnell's legacy. Trump was just there, and Mitch McConnell, and he ended up having this symbiotic relationship when it came to that. I don't think Donald Trump cares that much about judges unless he happens to be in front of one in his own case every so often. Okay. I find the intellectual positions of the Federalist Society often to be cogent, often to be structured, and for the most part, I find them to be wrong. There's a certain sophistication to them. They are so-called conservatives, many times originalists, and when the rubber hits the road, they're really not that conservative. They're not that originalist, and I frankly think they're activist judges. But if you're a conservative, for some reason, you never get called an activist judge. But these judges clearly are, as was evidenced by the recent case with religious liberty versus the regulations of New York during COVID and the position of Amy Coney Barrett in those changes. All right, so the Federalist Society, restoring the legal culture. They have created a mythology that somehow the courts have gone way, way, way too liberal to the left, and their goal is to restore the courts to something. Basically, I mean, I think it begs the question, restore it to what? So can a Supreme Court justice be impeached? Article 2, Section 4 says, President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and convicted of treason, bribery, or other high crimes and misdemeanors. Okay. Basically, the House of Representatives, as we know, puts articles of impeachment. The Senate tries all cases. Impeached officials means if you get impeached and convicted, it's automatic removal and not subject to any judicial review. That's Nixon versus the United States, 1993. Samuel Chase was impeached in 1804, on March 12th, 1804. Basically for conduct that he did in the lower courts, writing circuit, for continually promoting his political agenda on the bench, thereby tending to prostitute the high judicial character with which he was invested to the low purpose of an electioneering partisan. Vice President Aaron Burr presided over it, and Congressman John Randolph was the prosecutor. And what basically happened is the Senate acquitted Chase on March 1st, 1805, and basically has set a precedent that we don't impeach judges for their rulings from the bench. A judge can be impeached for some kind of malfeasance, taking a bribe, whatever. But we've got a precedent that just because we don't like their rulings, we shouldn't impeach judges. And I think that's an important aspect of judicial independence, even though the judiciary today is really not our friend. So what about this idea of packing the court? Well, the first Supreme Court, by the way, only had 6 justices. The Judiciary Act of 1789, September 24, 1789, put them in. They were all approved within 2 days, which is the fastest nomination kind of in history of that many justices. George Washington was actually the most effective court packer because he got 14 nominations to the Supreme Court. Now, a lot of that had to do because people didn't hang around the Supreme Court all that long. They either left, did something else, or they died or got sick or didn't show up. John Rutledge, for instance, refused to attend because he was not made Chief Justice. So he never showed up. Poor Robert Harrison died before he could take his seat. John Jay was the first Chief Justice, and they met here in the Merchants Exchange on Broad Street in New York. The court actually didn't hear its first case until more than a year later, which was West versus Barnes. However, this court did decide some key cases like Chisholm versus Georgia, answering the question as, do the people of the United States form a nation? Now, that's pretty fundamental stuff. I mean, you got to answer that question before you can have anything else, and they did. And by the way, we are. Now, after failing to show up for the first session, Rutledge resigned to become Chief Justice of South Carolina. Chief Justice Jay resigned after 5 years. Washington replaced him with Rutledge in a recess appointment. The Senate later voted him out by 14-10 for being too political. So he got knocked out. Rutledge didn't take it too well. Because of the Senate's rejection, he attempted suicide by jumping off a wharf, and he resigns on December 28, 1795, with the briefest tenure of any Chief Justice in the United States, which was only 138 days. Which brought us then John Marshall, who really is the one who molded and formed the Supreme Court as we know it. A really long tenure, gets his own postage stamp, and there we go. Now, what happened was by 1860, we had raised the number of justices from 6 to 9. And the reason for that is the justices had to ride circuit. So as the country grew, they needed to add justices to fulfill the duties of riding circuit. Justices spent most of their time riding circuit. After 1802, 1 justice was assigned to each circuit, and they grew as the country grew, which, by the way, is why court begins with the October term. Every Supreme Court begins with the October term. We're in October term 2019, I believe, right? And that's because they spent all spring and summer riding circuit out throughout the country, ruling on cases. So, October term 2006, October term 2007. Now, Abraham Lincoln was the first real court packer. What happened was Stephen Johnson Field, he put there, he wanted to create an anti-slavery majority and overturn Chief Justice Taney's 1857 Dred Scott decision. So what he did is he added a 10th justice, and Congress voted to add the 10th justice in order to change the composition of court. Now, the most the court has ever had has been 10 justices. Okay. Eventually, Lincoln appointed 4 associate justices and 1 chief justice, and he got Congress in 1863 to give him the 10th justice. Now, if you remember during the debate, Kamala Harris made a comment that Abraham Lincoln, in a similar situation in 1864, did not appoint the new Chief Justice because, the people should speak and the election should happen. Well, that is factually true. Abraham Lincoln did not do that. Lincoln didn't fill the seat this close to an election. What happened was Roger Taney died on October 12, 1864. Now, the real reason, though, is Congress wasn't in session after the election and wasn't going to be in session until December anyway. So we really couldn't have gotten the appointment through because there was no Congress seating, no Senate seating. Also, the person he ended up nominating in 1865 was Salmon Chase. Now, if you've ever read Doris Kearns Goodwin's book on Team of Rivals, Lincoln wanted to keep Salmon Chase's support by dangling the Supreme Court position over him until after the election of 1864. Because you never knew if Salmon Chase was just going to go off on his own and support somebody else. So Lincoln thought, well, if I appoint him in 1864, I can't be assured of his loyalty. If I hold it dangling on his head, because, Lincoln was a pretty damn smart politician. And so basically, when Kamala Harris says, yeah, Lincoln didn't do that this close to an election, she is factually correct, but not exactly because Abraham Lincoln had such pure motives on that. So that was kind of the history behind that. Okay, so what happens with the court? Why did we go back down the 9? Well, okay, look, Andrew Johnson was added to the ticket in 1864 to grab the border states. Andrew Johnson was terrible. After Lincoln's assassination and his murder, Johnson had a very cantankerous relationship with Congress, widely viewed up until this point as the worst president in the United States history. I think Andrew Johnson is probably happy in his grave right now because he will never be considered the worst president in United States history anymore. He wanted to, in 1866, nominate Henry Stanbury to the Supreme Court. And what Congress did was it just eliminated the seat rather than have Stanbury appointed because they wanted to tweak Andrew Johnson. And then they lowered the number of justices to 7 to make sure that Andrew Johnson was never going to get an appointment to the Supreme Court while he was president. Because realize it's Congress that sets the number of seats. Now, if you have a justice who's sitting in a seat, you can't take the seat away. Once you're a justice, you're always a justice. Okay, that's what the Constitution provides, life tenure, and you can't mess with their salaries, right? But nothing says that Congress can't lower the number of justices to 7. And when people resign, drop off, or die, you just don't fill those seats. Okay, and that's what they did. Well, okay, what happens? Grant gets elected in 1869. Now, he, of course, is a Republican, back when being a Republican was what you wanted to be in terms of racial issues. And the Republican Congress, through the Judiciary Act of 1869, went ahead and set the number back to 9. So Grant immediately got 2 justices the moment he stepped in the White House. And it was William Strong and Joseph Bradley. Joseph Bradley later wrote some horrible opinions interpreting the 14th Amendment, because that's the book I'm writing right now, is the history of the 13th, 14th, and 15th Amendment. But the point is, Grant got that power immediately, and it's been 9 justices ever since 1869. That's where it stayed. Now, if you recall, President Roosevelt wanted to pack the bill because the 9 justices weren't helping him out too much on New Deal legislation. The Judicial Procedures Reform Bill of 1937 came in. He wanted to add more justices to get better rulings. Basically, in 1936, Roosevelt won by a landslide, re-election. And the bill would have allowed Roosevelt to appoint a new justice for every justice over 70 in 6 months, for a total of 6 justices, which meant the court could have been risen to the number of 15 justices, which would have just been very unwieldy, but that would have totally changed the dynamic of the court. Now, Henry F. Ashurst was a senator from Arizona. So this is how Arizona comes into this story. He was known as the Dean of Inconsistency. He was also the silver-tongued sunbeam of the painted desert. He was a real, lot of language. He actually got on board and sponsored the bill. I'm for it. It's a step in the right direction. It will be enacted into law immediately. Well, that's not really what happened. What he did is it went to the Senate Judiciary Committee, where he was the chair, and he held the bill up for 165 days until it died in the Senate. His motto for that was no haste, no hurry, no waste, no worry. That is the motto of this committee. So that's what he said when he basically killed Roosevelt's bill. There was another sponsor of the bill that ended up dying in office. And so the whole bill ended up dying. And there was some negative popular opinion about packing the court at that point, which is what happened with Roosevelt's court packing plan. Okay. Now, by the way, the Republicans were, at least the Fox News Republicans, which I think you should do a distinction from kind of the real principled Republicans versus kind of the Fox News crazy Republicans, were trying to tap in, oh, wouldn't it be terrible? Trying to make an election issue about whether Biden would pack the court and trying to lock him in on that. I think they're trying to tap into this history that the American people, in their opinion, don't like court packing. Frankly, I don't think the American people care that much about whether you pack the court. I don't advocate for packing the court. The court's going to shift. The next oldest justice right now is Clarence Thomas. You know, just hope that he eats a lot of red meat and move on. And that'll drastically start to shift the court back. And what's going on to the federal judiciary is the bigger problem even than the Supreme Court. There's all these decisions handed down in courts of appeals and circuit courts, et cetera, where, you know, you can't have much control over that. So we just weather through this. All right, Amherst was defeated in the 1940 Democratic election by Ernest McFarland, but he had a cameo appearance in the movie Advise and Consent as a Senator McCafferty. Remember the Henry Fonda movie? Great movie. I'd recommend it to anybody. Dig it up in your DVD or whatever player for that. Charles Laughlin, all kinds of people in that movie. All right. Well, what also happens, by the way, is Justice Robert Owens, who was writing for the court, upheld Washington's state minimum wage law in West Coast Hotel versus Parrish. It looked like Justice Roberts has shifted to support the New Deal. This is known as the switch in time to save nine, and kind of killed the idea that they needed to pack the court because they got a different ruling. Recent scholarship has said that actually Roberts' opinion was already drafted before the court packing plan came in, but that was what was known to history as why the court packing plan ended up dying. Let me talk a little bit about Donald Trump and the census and make one final point here, and then we can open up to questions about the litigation and what's going on. There's a census counting case in the Supreme Court. I believe it's being heard today. And the issue is, do you count people who are not citizens in the census? Well, the easy answer is yes, you do. The country has always counted people. The Constitution says you count the number of whole people. Well, there's a specific reason why. The Constitution always counted non-citizens because the slave-holding South, the slave power, wanted to make sure that all slaves who were not citizens, all of whom were not citizens, indeed most black people in the South, even if they were free, were not considered citizens in most states. They wanted to make sure they were counted. Now, the other clause of the Constitution is the 3/5 clause. They would only be counted as 3/5 for purposes of congressional apportionment and the Electoral College, but there were any number of other benefits where the whole person needed to be counted. So from the Southern slave-holding power, slave power, the slavers' point of view, you wanted to count the whole persons, even if later on you counted them as 3/5, but every person needed to be counted and citizenship didn't matter. Okay, so now the Trump folks are saying with Confederate flags, don't count the non-citizens. Yeah, even though our great-grandpappies did. All right, so basically, I don't want to make any hard predictions. I predict the court will not do that. That the historical, from the day one of the Constitution, has always been to count all persons, because, you know, after all, it says we the people. It doesn't say we the citizens in the Constitutions. And Jefferson said in the Declaration of Independence, all people, all men are created equal. It didn't say all citizens are created equal. It's a philosophical concept of inalienable rights, which belongs to everybody, not just the citizen. Okay. The only wild cards is if Amy Coney Barrett and Clarence Thomas get together and want to really tweak the whole thing, because like I said, they're very activist judges. Well, then we might have a change. But versus that, I don't imagine Trump is going to have any greater luck with that litigation than he has with others. All right. So let's go off and make the Constitution great again. And do you have any questions?
All right, I want to open the floor for questions. You can send a question in the chat and I'll be happy to ask it for you. Or you can just go into participants, you raise your blue hand and you can ask a question. And just to get the ball rolling, Bob, I'd be very curious to get your take on the 40 lawsuits that Trump has filed in the 6 battleground states, none of the courts have found any instance of fraud. But what's your take on the president doing this, trying to disenfranchise America's voters?
Well, it's just simply craziness. I see a question here in the thing. Can Giuliani be disbarred for his conduct, which relates to this? I have often thought, I have, by the way, another hour-and-a-half long talk on ethics and the president's lawyers, featuring none other than Rudy Giuliani. And the end of the talk basically is, if you want to be an ethical lawyer, think about everything that Rudy Giuliani has done, and then don't do that. And you're going to stay an ethical lawyer, okay? Because the guy is he's just a hot mess. The guy's a disaster in terms of lawyer ethics. I have just popped in the mailbox today a bar complaint against 2 of the Republican lawyers here in Arizona challenging the election. They went to a hearing and alleged all this huge fraud and went to the hearing and says, well, there really isn't that. Well, you know, we as lawyers are not supposed to file frivolous lawsuits. And I know that's a pretty low bar, but I mean, come on, you can't file a lawsuit alleging huge voter fraud and get a bunch of publicity and then go to the hearing and just say, well, we really don't have that. Okay. So that bar complaint's in. Larry, remind me, I'll send you a copy of it if you want for your membership to read.
Oh,
it.
yes. I'd be delighted to see that and distribute it far and wide.
Yeah, good. I'll send it to you. So, but in terms of these lawsuits, they get to be fascinating. I'll give you an example. The lawsuits in Pennsylvania. On the one hand, the crux of the Trump position and the lawsuits are that the state legislature did not have either the constitutional or statutory authority or federal authority to expand mail-in voting. Okay. Basically, they're saying, look, you have to have the states decide how voting is conducted in the United States. Each state does it differently. And what they're basically saying is the Pennsylvania plan is, you know, out of the statute. Okay, so all those mail-in ballots have to go. They can't count, right? Well, at the same time, they're also arguing to Rudy Giuliani and others, and certain state legislatures, you know, kind of the Trump sycophants, are arguing seriously that because there was fraud, the state legislature should suspend their own statute, which says that whoever wins the popular vote gets the electoral votes, and put in a slate of Republican electors. And so they're making these arguments at the same time. One, saying that the legislature went beyond its authority, and 2, that they have the authority to nullify a popular vote. Okay. And that's why these things are just getting turned out. By the way, this group may be a little bit different, but I would imagine that almost everybody on this call, on this Zoom meeting, and myself included, have never actually voted for president of the United States. Most of you have not. What you voted for is a slate of electors. Now, I assume we have some electors here for the Democratic Party. The Democrats and the Republicans each have their slate of electors. We have a statute, which is 16-212, which says that, look, electors have to vote for the party that wins the popular vote. So you voted for your slate of electors. And so what they're trying to do here in Arizona and other places, and they usually don't have these meetings in the legislature, they have them in hotel conference rooms or some silly thing for the press conference value, is to try to get the state legislature and Republican-controlled legislatures to just nullify the popular vote and send in the Republican slate of electors, which is against the statutes, et cetera. I don't think that's going to go anyplace. And if it did, it would probably be a gift from heaven for all of us, because I don't think it's going to overturn the election. And that's just crazy. I mean, when you clearly go against the popular vote, that's just craziness. And they're starting to leave, even on this one, it's just been finally a bridge too far for the Republicans supporting Trump on this stuff. So.
All right, I've got a number of questions here. Let's see. Ellen Parrish would like to know, is there any real threat that Trump's failed lawsuits, all 40 of them, will result in a Supreme Court ruling on the Electoral College?
No, And I'm not sure, the Electoral College, again, I don't see any of them going anyplace. And his attempt to replay Bush versus Gore, I just don't see that happening. The victory was just too much. I mean, one of his things now is, how could Joe Biden get 80 million votes when Barack Obama didn't get that much? Okay, well, that's a simple answer. More people voted. So he's trying to shift the burden and say that Biden needs to prove all 80 million were valid. No, you challenge an election, you have to prove that they weren't valid, not that they're valid. There's a presumption of validity to a ballot. So I just don't see them going anyplace in terms of that. I will say, I think we talked about the Electoral College last time. There's things we can do about it. I don't see the Constitution being amended, because in the 5 times where the popular vote was different than the electoral vote, the Republicans have always won. So I don't see them changing. The only reason I personally see a value in the Electoral College is I understand how it works. But other than that, there's no value in keeping it. I mean, just because, I understand how it works, which is great, but other than that, there's no value to keep it. Done. So, at any rate, that's with the Electoral College. I would like to see Arizona, by the way, do what Nebraska and Maine do, which is apportion electors according to the popular vote. So in 2016, Donald Trump got 11 Arizona electoral votes. If you would have apportioned it, Hillary Clinton would have gotten 5 and Trump would have gotten 6. And if you did that, it would actually make, I think, candidates reach out more. For instance, a Democrat would go to Texas and campaign, and a Republican would go to California, because they could pick up some of the electoral votes in those other places where, no Republican candidate for president is ever going to go to California. Nor will a Democrat go to Texas, because it's a waste of time. But there's a lot of Democrats in Texas, and there's a lot of Republicans in California. And so if you did the apportionment way of selecting that, that would be good. So.
All right. Jacqueline Romer has a question, and she says the attentive liberal public, including us, feels that things are pretty out of control in Washington, D.C. And the worry is that Donald Trump will not leave office, or is planning a real overturn of democracy. Do constitutional lawyers in general feel the same concern?
I don't think there is. Doris Kearns Goodwin was asked this some years ago, and her response is, not on the day it happens, the Secret Service will pack him out. And her belief in the institutions being strong enough to do that. I don't see him getting the kind of Republican support for that. A lot of people would really come out then at that point if he did that. And if Donald Trump did that, I mean, I'm a very peaceable, law-abiding guy. I'd shoot him. If that ends up in the press, I was speaking rhetorically. Okay, just so we get that.
That's right. You didn't mean to say that as a statement of fact.
No, it's just rhetorical, like Donald Trump's. Again, look, I don't think that's going to happen, and it's not something to worry about. But it is remarkable that we're talking about it, isn't it?
Yeah, pretty shocking. Question from Molly McCasson. She has a question about what's going on in Georgia. She read yesterday that they're trying to tie voter registration to car registration. In other words, if you don't have a car, you don't have a vote. How can this possibly not be illegal?
I'm going to put this in a broader context. What's legal or illegal is what they end up writing a statute to say. And there's really very few federal controls. The Constitution clearly says states define who gets to vote, with the exception of the constraints of the 15th and 19th Amendments. 19th Amendment, of course, giving women the right to vote. 15th Amendment, making sure that race isn't a disqualifier for voting, okay? But other than that, states define that stuff. And this is something that I think is important to bring up to kind of principled Republicans. And that is, why is it that every single time there's some way that limits the vote, Republicans are always behind it? And every time we have the desire to expand the franchise, Democrats are behind that. Now, you could argue one thing or another, and okay, maybe this is bad, or maybe this would create kind of a fraud situation, whatever. But once you cut through all those arguments, it's pretty indefensible when you have a party that every single time tries to limit the franchise. Every time. And I think that's the point. And you can talk about all the different mechanisms that get used, tie it to driver's license, tie it to this, do this, whatever. But it's always in modern history, the Republicans perpetuating the limiting the franchise. And I think that's a point that, people have to be answerable to.
All right, we have a live question from Craig Markin. Craig, go ahead and unmute yourself. There we go, and ask your question.
Well, on the Supreme Court topic, there was a discussion about term limits. What would be the ramifications of such an item?
You can't do it unless you change the Constitution. The Constitution says you have life tenure. Now, there has been a plan floated around that you replace justices when they're 70, but then you allow the past 70 justices to go to the lower federal courts and work on the courts of appeals or trial courts, district courts. And so somehow that would pass constitutional muster. I don't think it does. What it says is you're clearly appointed to the Supreme Court. Now, Supreme Court justices can sit as lower court justices, and they have historically. Often when a justice retires, they will do that. John Paul Stevens has sat on Court of Appeals cases and district court cases as a trial judge after the retirement. Different judges will do that at times. But to force them to do that, I just don't think that would be constitutional. And frankly, the interesting thing about that is the place where that would be decided, whether that's constitutional, whether you can do that to a Supreme Court justice, is
The Supreme
Court. So I don't see that as a possibility limiting tenure, unless you did a constitutional amendment. Now, in Arizona, you have to retire when you're 70 years old from the bench. So we've actually lost some really good justices because they had to retire at 70, who still had productive years in them. And of course, that's also a way to get rid of bad justices. But yeah,
so with all the challenges and the stuff going on, is this process we've been seeing evidence that our Constitution is strong and our democracy actually worked? Thank you.
The answer is two things. Absolutely yes. And I'm going to feel a lot better about it after Joe Biden gets inaugurated. So.
All right. Let's see what else we've got here.
Let me just expand that just a little bit. Trump has been, over these course of 4 years, astoundingly ineffective at passing legislation. Most of his provisions are tied up in the courts, including building the wall. And that continues. He's done everything by executive order, which an ex-president can nullify in a stroke of a pen. It's the constitutional structure that at every point has hindered him and people like Stephen Miller, who are running these policies in his name. So the structure has been under stress, but it has served us well to limit Donald Trump. I'm very hopeful about the constitutional structure.
Paula Schlussberg says that something she caught on the radio this morning indicated that Native Americans were not counted in the census initially, that they were regarded as citizens of a foreign sovereign nation. And she presumes that's been changed.
Yes.
Can you comment on that or explain
That is absolutely correct. They were not counted as citizens, nor, of course, were Black people, nor, frankly, were women in the original Constitution. And what's happened, I think the phrase was Native Americans not taxed once you were taxed by the state, it changed your status and you're now counted as part of the body politic. That is an area that is kind of a thicket. And I have only a superficial knowledge of the Constitution as it relates to Native Americans. It's not been my area of focus as much. But yeah, initially Native Americans weren't counted. They are counted now. And a lot of the issues, by the way, was the undercounting of Native Americans, especially on the Navajo reservation, which is quite vast. And that is still a persistent problem in the census process.
I've got a question about the recent Supreme Court decision where the Roman Catholic Church went to the Supreme Court and said, we don't want COVID-19 restrictions imposed on us by the mayor of New York. And the Catholics on the US Supreme Court voted for their own church. Do you see that as a conflict of interest? Should they have recused themselves?
Yeah, look, I don't find it so much of a conflict of interest. Now, Supreme Court justices, you know, make those decisions themselves. There's not a court above them judging whether they have a conflict. First of all, you know, the court went out of its way. The governor of New York had already changed those regulations. So the issue was moot. And they very easily and should have just said, sorry, the issue's moot. We don't talk about that anymore. We only decide cases and controversies, right? But the court went out of its way to do that. And what I think it was signaling that this is a court that's going to perpetuate its notion of the free exercise clause of the Constitution over the anti-establishment clause of the Constitution. The paradigm in the court for decades has been the separation of church and state, the anti-establishment clause, and this is a court that's going to favor the free exercise clause. Now, I think that's very, very problematic because essentially the purpose of the anti-establishment clause is actually to guarantee the free exercise clause of religious and non-religious, atheists, agnostic, whatever, their right to participate in the public forum, public discourse. So if you start having established religions, which the framers of the Constitution knew, it does nothing but creates problems, which is why we try to maintain this separation of church and state, which, by the way, does not just protect the state, it protects the church from being used as a vehicle and tool of political powers. All right. When you have every candidate in the Republican primary 4 years ago standing up and saying God told them to run for office, that's something that would cause the framers of the Constitution to cringe. It also kind of says to me as a practicing Catholic that, well, if that's the case, God is really messing with somebody, because if he told them all to run and then they all ran and then he gives a nomination to Donald Trump, who said God doesn't have a sense of humor? So there we go. But it's corrupting for religion as much as, and this is what the framers believed in, was it's as corrupting for religion as it is corrupting for the body politic. So this is a court that's going to be favoring the free exercise clause. And as Larry and I were talking a little bit this morning about, I have a whole nother kind of presentation on this that lasts about an hour. But what that does is you get the free exercise of clause. You know, religious liberty is an individual right. But for very many people, it's expressed within the context of a collective faith experience. Catholics are notable. Jewish persons who also were in that case are notable. Different large denominations express their individual right in a group experience or a communitarian experience. But fundamentally, it's an individual right. Now, part of that too is, if my belief is that I have to convert you to Catholicism to save you, Larry, well, then to save your soul, I should use any means at my disposal. And that definitely bumps up against the anti-establishment clause, which says, well, no, Larry gets to be left alone. Larry has the right to do what he wants with his own individual thought. All right. So the free exercise clause lets you believe anything you want, but it does not clearly let you do anything you want. And my favorite example is let's say I'm a practitioner of the Aztec religion. Well, I don't get to go plunge my obsidian dagger in people's hearts in the morning anymore and pull it out to make sure the sun rises. Okay. Nor do we allow Mormon polygamy, which was a case called McWhirter in the late 1800s. So there's clearly limitations to actions that you can do in the free exercise of your religious faith. And this is a court with Amy Coney Barrett on it now, with a majority for now that's going to be much more in favor of expanding the actions you can do as part of the dictates of your faith, at the risk of pushing on the anti-establishment clause. So that's the dynamic we're seeing.
Right, we're getting close to 1 p.m., but we have a couple of questions left. Maybe we have time to get one of them.
Sure.
Let's see. Susie Anderson, one of our board members, would like to know, what about the departments with regulatory powers like the Environmental Protection Agency and the regulations that have been made or unmade under Trump? Do you think there will be problems undoing those dangerous regulations by the new heads and staff of the Biden administration?
Oh, you should have attended my talk on the Constitution of Donald Trump, part 10, where I talked all about that. Look, I think first of all, the regulations can be withdrawn at any part of the regulatory process. The bigger problem is, for instance, if you have these leases getting passed up in Alaska to expand Arctic drilling, and if those leases are granted, there's contractual obligations that are hard for a later administration to get out of. That's the bigger problem going on, is the damage that's already been done. But anything that's in the works, the Biden administration can just pull the plug. And by the way, if there was any doubt about the presidential power to do that, Trump defined it for us pretty clearly. The Supreme Court has backed him up on this expansion of presidential power. And all the Republicans that were arguing about Obama having an imperial presidency, because toward the end of his tenure, he was very much using executive order, like what he did with DACA, executive orders, et cetera. Well, fine. Trump signed more of those in his first few months than Obama did in his entire 8 years. And the courts have upheld that. And if it's time for a review of that delegation of presidential power, I think that's true, but it would be for both sides. But right now, the president can do all that. And Biden, I anticipate, will and should.
All right, Bob, as a fellow attorney, I could listen to you all day, and I'm sorry I missed part 10. So, we all want to know, how can we get in touch with you? How can we hear parts 1 through 10 of your presentation?
I'll try to see if they're on. Frankly, I think there's good ways to learn about the Constitution, but frankly, if my talks have to go into the dustbin of history to make sure Donald Trump goes there too, I'm okay with that.
Well, listen, Bob, we want to thank you very much for speaking to Democrats of Greater Tucson today. Yet another fascinating program. And I want to thank you on behalf of the Democrats of Greater Tucson, and also wish everybody on the call my gratitude for coming out. And we'll see you at the next meeting on December 7th, when we have our annual elections. And with that, we'll sign off and say so long.
Thank you all.
Thank you very much.
Bye, everybody.
Bye-bye, everyone.